Michael Irvin's $100 million defamation lawsuit against Marriott is moving forward at explosive speed. The Eastern District of Texas, where Irvin's case is pending, is known as the rocket docket because of how quickly it moves through cases, and we can certainly see that in this case. Shortly after Irvin's emotional press conference on March 8th, the court in Irvin's case called an emergency hearing scheduled for today at 2 p.m. Let's take a look at the court's order. Here is the court's order. It states that the court hereby sets emergency plaintiff's motion to enforce court order. That's referring, of course, to the order that was requiring Marriott to produce the surveillance footage to Irvin by March 7th. It's setting that motion for hearing on Friday, March 10th, 2023 at 2 p.m. Later in the day, Marriott fired back by filing its response in opposition to Irvin's motion. Let's take a look at the highlights from Marriott's response. So here we have Marriott's response to Irvin's motion. It states that plaintiff's emergency, in sarcastic quotation marks, motion is legally flawed and premature. He ignores that Marriott not only complied with the court's order, but also produced documents ahead in advance of the deadline and specifically invited Mr. Irvin to view the footage himself, which he chose not to. Then Marriott goes on to make a couple arguments here. First, they say that on March 6th, Marriott promised that it would deliver to plaintiff's counsel copies of any non-privileged reports and witness statements pertaining to plaintiff's stay at the Renaissance Phoenix Downtown Hotel, which it did. I thought it was interesting that the attorney for Michael Irvin did not ever mention anything from the investigation reports or the witness statements that he would have received on March 6th. That was never once mentioned during the press conference. The only thing that was ever mentioned by Irvin's attorney was the surveillance footage during that press conference. So I definitely think that the public would like to see and would benefit from seeing Marriott's investigation report and any witness statements that it did turn over. That would be interesting, and Irvin's attorney has those. He should turn those over to the public, to the news, and let us evaluate the case. Then going on, Marriott makes a second argument. It says it would make the pertinent video recording available for plaintiff and his counsel's inspection. Emphasis on inspection as opposed to copying. That may seem like a hair-splitting argument, a trivial turn of phrase, but remember, words do matter, especially here. Words make a difference between whether Irvin gets to see that video or not. Then it says, in accordance with the court's order permitting Marriott to, quote, take reasonable measures to protect the employee's identity, end quote, Marriott also advised plaintiff's counsel that no recording or removal of the video recordings would be permitted. And of course, that was one of the main points that Irvin's attorney was complaining about during the press conference on March 8th. Then it says, given plaintiff's repeatedly stated intent, including in a press conference this morning, so obviously Marriott's lawyers saw that, to disclose the video publicly, which would substantially risk compromising the identity and privacy of the employees and the hotel guests visible on the video, it is apparent that producing the video for inspection, as Rule 34 allows, was both reasonable and necessary. Then it goes on to say that although plaintiff Irvin vaguely complained that Marriott's proposed method of production did not fully comply with the court's order, he ignored Marriott's request to explain the basis for any objection. So let's go ahead and take a look at the Exhibit A that Marriott attached to its response. Here is Marriott's Exhibit A that it attached to its response. It's a letter dated March 3rd, 2023 to Irvin's attorney right here from Marriott's attorney. It states that pursuant to the court's order dated March 1, in the above referenced matter, copies of the non-privileged written reports and witness statements gathered that pertain to Michael Irvin's stay at the Renaissance Phoenix Downtown Hotel in February 2023 will be delivered to your office on March 6, 2023. Then it goes on to say the video recordings referenced in the court's order will be available for plaintiffs and his counsel's visual inspection at the law offices of Cozen O'Connor. And then it gives the address here. It goes on to say that no recording or removal of the video recordings will be permitted, and your personal electronic devices, including phones, tablets, etc., must be left at the front desk during the viewing. Then it goes on to say, please provide us with the names of the individuals who plan to attend and no more than 3, so we can provide their names to security. Marriott is protecting this surveillance footage like it is the gold located inside the depths of Fort Knox. It's very strange. So back to Marriott's response here. Marriott goes on to say that plaintiff Irvin also ignored Marriott's express invitation to review personally the video footage for himself on March 7th, opting to have 3 of his attorneys view it instead and to hold a press conference today wherein he inexplicably complained that he was not able to review the video. The response goes on to say that Marriott's counsel again invited plaintiff's counsel to speak to them in good faith as to the specific areas in which he believed the production was non-compliant. And then it says, see Exhibit C. So let's take a look at Exhibit C. Here you can see the Exhibit C that Marriott attached to its motion. It's an email from Marriott's attorney on March 7th, 2023 to Irvin's attorney. And in it, he says, Levi, it was good to meet you today. As per our discussion, we believe the inspection fully complies with Rule 34 and the court's order. To the extent you have concerns in that regard, we invite you to confer with us on the specific areas in which you believe the production was non-compliant. In the further interest of attempting to resolve a potential dispute without further court intervention, I will speak with my client today regarding your request to share the video with the NFL and whether we can provide you with copies of the videos pursuant to an appropriate protective order. As I mentioned today, my client's, that would be Marriott's, preeminent concern is the safety and privacy of its employees and guests, several of whom appear on the video and whose interests may be compromised by public disclosure of the video. Again, I don't understand this argument because it would be so easy for Marriott to simply blur out or even box out any of the guests or employees that it needs to and still produce the video footage. So this just rings hollow. This argument does not make sense to me. Now, moving back to Marriott's response, they go on to say that Marriott's counsel further represented that he would confer with Marriott regarding whether a copy of the video could be provided to the NFL and plaintiff pursuant to an appropriate protective order. After receiving no response, Marriott's counsel followed up later in the day to inform plaintiff's counsel that he was discussing plaintiff's request with Marriott. And then it says, see Exhibit D. And then Exhibit D was interesting because it is an email, as you'll see in a second, that suggests that Marriott and not its lawyers is calling the shots here, that Marriott is the one that ultimately made the decision not to produce the video to Irvin. So here we have Marriott's Exhibit D in a follow-up email on March 7th, that same day at 10:33 p.m. It states, Levi, we have communicated your request to our client and we'll get back to you once we hear back. So apparently the attorney for Marriott was able to get in touch with whoever is actually calling the shots at Marriott and ask them whether or not they can produce a copy of the surveillance footage to Irvin's lawyer. That was past the deadline that Marriott had to actually turn over that footage. So they were already past the deadline. Now, moving back to Marriott's response, Marriott makes a legal argument here. The federal rule of civil procedure governing the production of documents and other materials states that a party may serve on any other party a request within the scope of that rule to produce and permit the requesting party or its representative to inspect, copy, test, or sample. And the emphasis here is on or. Or is being used in the disjunctive, meaning any of these will comply with the rule, either an inspection of the video or a copying of the video or a testing or a sample of the video. Now, this argument, some courts have rejected it and other courts have accepted it. Marriott, of course, goes on down here to actually cite various cases where courts have said, yeah, you don't necessarily have to produce a copy of something if you allow them to at least inspect it. But that rule is more intended to protect the producing party from having to bear the cost of producing something over. You can allow somebody, instead of producing a copy of something in a case, you can allow the other side to come and inspect it and make their own copies of it and pay for their own copies of it. So down here, Marriott makes the argument that as this court and many others have recognized, inspection is a proper, indeed the default method of production under Rule 34. And neither the rule nor any authority requires that a requesting party be provided a copy at the producing party's expense or be permitted to make his own copy. And then cites some case law down here. I will say that that is absolutely not true with respect to Marriott's representation that the default method of production under Rule 34 is allowing inspection and not just producing a copy of something. The default in almost every case, except for cases dealing with trade secrets or some sort of other sensitive information, is that you will produce whatever the other side is requesting. You will produce that in a digital file, usually in PDFs of emails responsive documents, whatever the case may be, you're producing that over to the other side, copies of that, and you're representing that these are true and correct copies of whatever you're producing to the other side. So the default is not an inspection instead of producing copies. On the next page of Marriott's response, Marriott is making the argument that Irvin does not explain why he could not have attended the inspection himself, viewed the video as many times as he wanted, and discussed it privately with his counsel in a separate conference room, which Marriott could have provided, but plaintiff did not request and declined to even discuss. Like his failure to confer, plaintiff's acknowledgement of Marriott's concerns regarding the privacy of its guests and employees is significant. And then down here, Marriott argues that should the court be inclined to order that Marriott produce a copy of the video recordings to Irvin, Marriott requests that the court first enter a protective order providing that plaintiff, number one, may not use any information produced by Marriott in discovery other than for purposes of litigating this case. Number two, may disclose such information only to Irvin and his attorneys of record. And number three, may not publicly disclose such information. So in other words, Marriott is asking the court that, Judge, if you do force us to turn over this tape, please at least enter an order that restricts Irvin from being able to actually show the public what is in the surveillance footage. So I would be really surprised if the judge just enters a protective order granting all of the restrictions that Marriott is asking for here. I think a more reasonable middle ground approach would be to enter a protective order that simply requires Marriott to give Irvin a public copy that has blurred out faces, blurred out or redacted bodies, and then give a private, confidential version of that footage that is unaltered, has no blur, has no redactions. Give that to Irvin subject to a more restrictive protective order that says you can see this, but you cannot disclose this to the public, because this case is a defamation case involving a public figure. And one of the fundamental tenets of our judicial system is the right to public access to our courts. And that includes all of the evidence and documents that are filed in the case. Here, you've got a public figure who has been accused very publicly and canceled very publicly of wrongdoing, and he has an understandable desire to clear his name as quickly as possible. If you don't want to miss any of my updates on this case, make sure to hit that subscribe button below and turn the bell notification icon on. And of course, as always, thank you for watching.